biotech industry. Anyone can tell? What is the legal research and then a patentable invention? How courts are recognized as a patentable invention and how a natural process. You all know that biotech industry is not a new for the human life. It's a old industry as civilization, and we all know about the how people have made the curds and the bread using the yeast and other by way of fermentation. So this entire process has been only a natural process. Okay. So it's alliance between the biology and the technology. See, biology has evolved as a field of biotechnology with the help of the modification of the natural process into a technical process with the human intervention. So you can see that wine and beer were prepared in 6000 BC and the curd and bread in 4000 BC. So it's not old, but there they used only the natural processes. They have not made anything new and anything novel for the technology. It's only natural process. Existing natural technology, they are just reused for the manufacture of the wine and beer. So traditional biotech is a natural process. You know, as far as the modern biotechnology is concerned, it's genetic manipulations, cell fusion, improvement made in the natural processes. That is important. So existing natural process, they made improvement, and then it becomes a researchable field from the natural process to research field. So what is the biotechnology? It's a use of microbial, animal or plant cells or enzymes to synthesize, break down or transform the materials into some other form, which can be used in any industry which related to which will have its own effect on this. And they call the classes of techniques. It's a cell culture. As you know, the growing of cells under a controlled condition called as a cell culture, and based on that, see, for example, multicellular eukaryotes from animal cells can be derived with the help of the cell culture. And hybridoma technology, it's another technology. So producing the B cell with myeloma cell, it's of a cancerous nature. And to grow the cell culture in the absence of the antibody chain synthesis. And another technology is the recombinant DNA tech. See, artificial DNA can be created by combining two or more sequences, but normally it will not occur in the gene splicing. You know. And in 1974, the process of producing biologically functional molecular chimeras was invented, and its patent was granted in 1980. But interestingly, human insulin was produced in the lab in the year 1979. So you know about the diabetes patient in India and across the world. And we are no longer depends upon the animal insulin. So we are producing the human insulin and we make it as a commercially viable for the entire diabetes patients. So that is because of the biotechnology. So the technology is from the process, it has evolved as a technology. And the microorganism. So you can know that in copper mining it has been used as microorganism has been used in the copper mining, and thereafter Gregor Mendel, he has given an inheritance of genetic characteristic in the microorganism. Thereafter, you know about the rabies vaccine by Louis Pasteur. Though it is not a patentable invention at that time, but it gives the research-oriented field. Moreover, it has changed the commercial viability of a microorganism, manufacturing a microorganism. And thereafter, Edward Buchner has extracted enzymes from the yeast in 1897 and sewage purification. See, in 1910, they detected that the sewage can be purified by employing the microorganism. But later on, another bacteria has been invented in order to purify the oil spills. That has made the breakthrough in the entire biotechnology industry. And industrial chemicals has produced biotechnology. The word was coined by Carl Herke and Alexander Fleming. This is important thing. Penicillin is discovered by Alexander Fleming. It is another form of discovery. So up to 1928, it's only a discovery. There is no patentable invention. And growth of DNA. Initially, DNA was detected as a genetic material in 1944. Thereafter, structure was determined by that for the DNA. And now in 1958, the replication of the DNA has been invented by the Massillon and Stahl. And 1961, this is an important period where the biotechnology and the bioengineering has been documented by launching the journal and the regulation has been formed by Jacob and Monod. And this is the establishment of recombinant DNA and genetic code and a restricted enzyme. Everything has been formed. This is after 1920. After discovery of penicillin, all these things have happened. And legalization of biotech. Because the guidelines were formed by the National Institute of Health for recombinant DNA research. And thereafter DNA sequence has been developed, and first genome of bacteriophage has been sequenced, and the production of human insulin in E. coli. See, earlier human insulin has been produced, but it is produced in the E. coli bacteria. And in 1980, the Supreme Court has given that microorganisms can be patentable in Diamond versus Chakravarti. This is a landmark judgment which created the natural process, research-oriented field, biology, into a patentable field, which can be commercially. See, you cannot have a protection without a patent. So you may have, for example, the making of bread and cheese. It can be done even without a patent, but any number of players can play in that. But you don't have any monopoly, you don't have any, so you are putting a research and you are putting your effort. But ultimately everyone can do that, then there is no legal protection for you. So this Diamond and Chakravarti in this case, so genetic engineer Anand Chakravarti is general bacterium. He has invented a bacterium to break down the crude oil, and he has claimed a patent application. He filed a patent in USA. It was rejected initially by the patent examiner. Thereafter, in the appeal, it has been upheld the decision of the patent engineer. Surprisingly, U.S. Court of Customs and Appeal reversed the decision of Board of Appeal. Thereafter, Sidney Diamond, Commissioner of Patents and Trademark, appealed to the Supreme Court. There, Supreme Court ruled. Chief Justice Warren Burger wrote a decision. A majority of 5-4 ruling upheld the patent, and it has held that human-made microorganism is patentable subject matter under U.S. Code 101. And they also held that microorganisms constitute a manufacture or composition of matter within that statute. And another important observation was that anything under the sun made by man can be patentable, and they made it as a product of a human ingenuity. I think other speakers will deal with this Diamond and Chakravarti in detail. And modern biotechnology. Thereafter, biotechnology has emerged as a different schemes and diagnostic tests, research tools, gene therapy, therapeutic protein sensors, bioinformatics, sequences, and also in pharmaceutical industry. So after this Diamond and Chakravarti, biotechnology has evolved as a field, not only in the pharmaceutical, it's also as a biotechnology as a separate field. So earlier it was a part of the pharmaceutical department. Now it has emerged as a biotechnology field, as a new field. And what are the patentable inventions under the Indian Act? I think novelty, inventive step, and it should be industrially applicable. But surprisingly, you can see what are non-patentable invention. Invention with frivolous claims, invention for commercial exploitation, mere scientific principle, mere discovery of new form of unknown substance obtained by mere admixture resulting only in the aggregation of properties, arrangement of known devices, method of agriculture, and process of medicinal or surgical. These are not patentable. You can see the plants, animals in whole or any part thereof other than microorganism. So they are made it as a clear that microorganism can be patentable under the Indian Patent Act, but including seeds, varieties and species which are covered under the Plant Varieties Protection Act, not under the Patents Act. And I am going to talk about how the process has made a commercial exploitation of the process. One. So chymosin, you know about the chymosin renin. It has been produced by the cows in the fourth chamber to ingest the milk, and it has been produced by recombinantly in E. coli, and it's been widely used in the commercial cheese making process. The same gene is found in humans also, but it's not yet been expressed. And because of this, this is only a extract of the chemicine from the cows, and thereafter they recombined in E. coli and used in the commercial cheese process. But it is not a patentable invention. But it leads to a lot of research. How a recombinant E. coli can be used for the commercial purpose for making cheese. Because earlier they used to slaughter the cows to produce this renin, chemosine renin. And the other is the Oncomos. It's an animal patent. This is the only animal which granted the patent in US, Europe and Canada. And the activated oncogen increases the mouse susceptibility to cancer and then makes mouse susceptible for cancer research. And the rights to the invention are owned by the DuPont, and Oncomos is also a registered trademark. Patent applications were filed in mid-80s in number of countries including USA, Canada, Europe and in Japan. And in Canada, US Supreme Court has rejected the patent, and thereafter on 7th October 2003 patent was granted to Harvard College by of amended to omit composition of matter. The Supreme Court has rejected the entire patent earlier, but application on the basis of these claims. But Canadian patent law allowed the amended claims to grant under pre-GATT rules, and the patent remains valid until 2020. Europe Patent Office. Application was filed in 1985, and they are initially refused by the examination division on the ground that it excludes the patentability of the animals per se, and Board of Appeal held that animal varieties were excluded of patentability, especially by its Article 53 Class B of European Patent Commission. But thereafter patent was granted in 1992. And European patent was opposed by the several parties, precisely by the 17 opponents, and according to which inventions the publication or exploitation which would be contrary to order or public morality are excluded from patentability under Article 53A of European Patent Commission. Thereafter, patent was maintained in the amended form after the oral proceeding. Their decision was appealed, and the appeal decision was taken on 6th July 2004. And the case was remitted to the first instance with an order to maintain a patent in a newly amended form. However, it has been revoked, and revocation has been published on 16th August 2006. And in United States, in 1988, USPTO granted the US patent to Harvard College. And the claim explicitly excluded the humans, apparently reflecting moral and legal concern about the patents on human beings and about modification of the human genome. Remarkably, there is no US courts called to decide on the validity of its patent. Apart from this, 2 separate patents were also issued to Harvard College for cell culture from transgenic non-human animal and testing the methods using the transgenic mice expressing an oncogene. And I am going to talk about the donor's right. This is an interesting case where John Moore is suffering from the leukemia cancer, and his spleen was removed, and most cell lines were developed by the inventors, which has not been informed to him, but he has consented for that. And he filed a suit seeking the profit, stating that he is also an inventor in this invention, and he wanted profit from that invention. But surprisingly, US court held that he cannot claim a share from the profits as neither as an inventor nor as an investor, but he can file a suit against the doctors for breach of fiduciary duty not to inform viability of a patentable invention from his spleen. Had I have any agreement with the doctors that anything taken from his spleen, if it comes under any patentable invention, then he would have some rights over it. But I think probably he would have got profit, but he missed that chance. But he has consented to take his spleen, and it can be researched. Because of his consent, he cannot claim any share over that patent. That's all. Any questions? Thank you. naturally occurring microprocess is not patentable. That's why it's hard. See, earlier it was under the natural process, that making of wine, beer and curd. That is not patentable. That is not patented also. But once that turned to the human-made invention, then it becomes patentable. That's what dealt in Diamond versus Chakravarti. I think other speakers will deal more detail about that case. Even in India also. Because natural process you cannot get claim.